law firm concentrated in men's and fathers' rights in divorce, custody, and family law matters, with offices in Nutley, Montclair, New Jersey. Today is Thursday, December 27th. I'm recording this in New Jersey, so if you're watching this at any point in time or in a different state, you need to check to make sure the laws haven't changed or that they apply to your situation. This is my weekly how-to video where I try to give you a medium amount of information on a topic that is prevalent in New Jersey family and divorce law. It's obviously not going to be that extensive. It's more than my daily tips are, and it's less than my webinars, but it's intended to give you a good chunk of information about a certain topic. Today's video is prompted by an interview I did with HLN Network today on custody rights of people who are convicted of crimes, and actually specifically crimes against the other parent. Although that's not really the topic, we're going to talk broadly on third-party rights, but that's usually what's involved in those kinds of cases. So today's how-to video is how to get custody of another person's child. And let me be clear, I'm not suggesting that you go out and file for custody of another person's child unless you have a compelling, legitimate reason to do so. And if you do, then these tips will help you along in New Jersey. So first, there's two issues that raise the possibility of obtaining custody of another person's child. You can't just simply say that that's something that you're seeking. The two most common situations: one, the parents themselves have decided that they do not want or cannot parent the children and are looking for an option. And two, more common, is where they've been found or demonstrating that they may be incapable of parenting a child because of some kind of risk of harm, abuse, or neglect. The options I'm going to talk about are going to apply really in both situations, but obviously it's less difficult and compelling if it's the parents who are seeking to do it as opposed to the parents unwillingly being found to be incapable of doing so. So the first issue is a third-party custody application, and that could be any person. Now, generally people think it's grandparents because that's something you hear a lot about in the media, and New Jersey has specific statutes for grandparent rights, but it really can be any person that has an interest or desire to have custody of somebody else's child. Second way, and the more common, is going to be through DCP&P, the State Organization for Child Welfare, otherwise known as DYFS. A lot of people think it's child welfare, but it's not. It's DCP&P. And then the third is through an adoption process through the court system. Now, let's talk just a little bit about each one. So a third person petition can be, again, from any person. You file it by submitting a motion to the family court in New Jersey. If it was the resulting custody came from a divorce case, you'd file the motion in the underlying divorce case. Otherwise, you'd file in what's called a non-dissolution proceeding. The court has some forms that you can use. They are actually prescribed forms that are required, so you need to use those. Even if you want to submit your own documentation, you need to use those forms. And again, anybody can file that. The issue there is going to be the best interest of the child, which will primarily be the issue in all of the cases where somebody else is taking custody of a child. But predominantly in this case, where it's another person and there's no consent of the parents, you need to show that it's in the child's best interest. Once you file your motion, if you have shown what's called a prima facie showing or an initial showing that there is a just reason to examine the petition, the court will schedule what's called a plenary hearing and some discovery to follow. Plenary hearing is a short but a full trial, so you can expect to have witnesses, maybe experts, exchange of documents, and anything you would have at a normal trial, just usually not as long. And from the time of the motion decision and the plenary hearing, you'll usually have the exchange of what's called discovery, which is basically what I talked about a moment ago, exchanging documents that are going to be relevant, getting expert reports and exchanging them, and notices to any witnesses you plan to call. Again, ultimately, it will be a best interest standard. New Jersey has a specific custody statute that I won't go into at length in this video because it's beyond the scope. But it will set forth the criteria. I think there's about 10 or 14 different issues the court is supposed to look at when determining a third person, actually any person's custody application. It's the same criteria if it's a third person as opposed to another parent or relative trying to change a custody award. Second way is through DCP&P, or formerly known as DYFS, Division of Youth and Family Services. Again, a lot of people call them Child Protective Services. That's a common phrase. We don't call that in New Jersey, but some people know it by that. That is a process when the Attorney General is the attorney's office that represents DCP&P. But if DCP&P determines that a parent has committed an act of abuse or neglect and it rises to such a level that they need to remove the child, they will then engage in two different processes to handle the custody of the child. The first is what's called a Title IX, and that's just the code under which the abuse and neglect proceeding originates. The first proceeding under a DCP&P removal would be to reunify the family. So at first, when they remove a child, they're always supposed to try to help the family remove whatever harm led to the child being removed from the house so that they can return the child. If that's not successful, they will move to a Title 30, which is termination of parental rights. That, again, is just the name of the statute under which it follows. If after that proceeding, the court has determined that the child's or the parent's rights should be terminated to the child, then that child later becomes available for adoption. Which brings us to the third area, and that is adoption. Again, it can be through a DCP&P hearing, it can be by consent of the parent, and it can be also through an agency that has already received the child and the proper approval and documentations for adoption. Now, adoption is a process by which one other person, third party, will file for custody of the other person's child, but this process is significantly different from any third-party custody or even DCP custody. Because when we talk about custody, we're talking about changing the legal and physical custody of the child, but a custody decision is always considered a temporary decision, meaning it can be changed at any point in time. As an aside, any two parents that have a custody arrangement, their agreement and arrangement is always temporary. If you filed for custody under the two issues I mentioned first, the third-party rights or DCP&P for custody, then you're getting what also is considered temporary because it can be changed again. Now, adoption is a process by which it becomes final. And it can be done independently of the first two. It can be part of or following the first two, but adoption is an entirely different proceeding. The purpose of it and the main distinction is you are actually going to be severing the natural parent's parental rights to that child, unlike the first two, third-party rights and DCP&P. So when you file for adoption, again, there's a pleading specifically that needs to be filed. There's a protocol that the court will send you through about certain notices that need to be posted, both for the parents as well as to other members of society, possibly even a criminal division just for notice purposes. And then there'll be another plenary hearing like I described for the third-party rights, but this will be to determine if it's in the child's best interest to be adopted by the other party and thereby terminating the natural parent's parental rights. It can be with or without the consent of either one or both of the parents, but it always has to obviously be on notice. And if it's without consent of either one of the two parents, and it's not through an agency and it's not through DCP&P placement, you'll have the burden of actually showing that that is in the child's best interest to have his or her natural parent's rights terminated. That burden will not exist if you receive it through an agency placement that has proper authority for adoption. Will not exist if you receive the child through a DCP&P placement after termination of parental rights. Now, again, I want to indicate that this is not to encourage you to seek custody of another person's child. It is a very complicated process. The parents of any child have a constitutional right to parent their child, so trying to take either temporary custody, a visitation or parenting schedule, as well as an adoption, is always a very compelling issue with the court. Also, to some extent, always harmful to a child. Anytime a child's rights are terminated from their natural parents for whatever reason, most experts will agree there's some modicum of harm to a child. So these are things you need to consider before you seek filing a petition. But if you do, hopefully this information will help guide you in the beginning of it. If you have any questions about this information, you can always call me at 973-562-0100. You can email me at brad@micklinlawgroup.com or send me a message for any questions you have or any other tips you'd like to see. If this information you found helpful, do me a favor, give it a like and share it so that other people get to see it. And I will be on probably tomorrow. I think I scheduled to be on tomorrow at 4 o'clock. Don't know what the tip is yet, so if there's something you want to specifically see, send me a message, okay? Thank you.